Hi everyone, a very warm welcome to Thorough Newspaper Analysis for the 3rd of May 2024. Now let's quickly proceed and have a look at the pointers of discussion for today. First of all, we have the editorial segment, and here we're going to discuss an Indian Express article with the title, How to Decide Domestic Violence Damages, Injury or Ability to Pay. See, essentially, there was a case before the Supreme Court wherein a proposition of law arose. So, Supreme Court has to now decide whether the compensation which is granted to a victim of domestic violence under Section 22 of the DV Act, whether it depends upon the injuries that she has sustained, or does it depend upon the financial status or upon the ability of the respondent to earn and pay. Secondly, we talk about the news updates, and this is going to be followed by the last segment of legal news. So without further ado, let's start with the article. Let's first see the title of it. How to decide domestic violence damages, injury or ability to pay. Let's start with the context of it, and I would like to first give you a brief undertone and a picture of the factual scenario of this case, and then we go to the proposition of law. So there was a matter pertaining to DV Act, that is the Protection of Women from Domestic Violence Act 2005. So there was a matter with respect to this act. Now the woman, she was before the trial court and the Bombay High Court. The trial court and the Bombay High Court ordered the husband to pay a compensation under Section 22. Now the quantum of compensation is the point of contention here. Both of these courts, they directed the husband to pay rupees 3 crore to his wife as compensation under Section 22. Now the husband is before the Supreme Court, arguing essentially that this compensation is on a very higher note and that the compensation should not depend upon his financial capabilities. Rather, it should depend upon the injury that has been inflicted upon the woman. So before the division bench of the Supreme Court, this is the proposition of law. Whether the compensation which is awarded under Section 22, it should correlate to the degree of domestic violence which is suffered by the victim, or is it linked to the financial status of the guilty party? Now, the Supreme Court last week issued a notice in this respect, as in respect of this case. So this is going to be an interesting, case law for all of us to track down in the coming days as to what the Supreme Court has to say on it. Now, let's understand what is the soul, what is the aim and preamble of the DV Act, what is the meaning of the term domestic violence under the DV Act, then what are some of the important definitions here, then we go to some of the reliefs that are available under the DV Act, and then we'll decide how Section 20 of the DV Act is different from Section 22. So let's just start with the preamble of this act quickly. The DV Act, it is intended to provide more effective protection of the rights of women which are guaranteed under the Constitution. So what are we targeting here? We're essentially trying to give more effective protection to all the rights that are available to women under the Constitution of India. Now, what group of women are we, catering to with this act? So we are essentially looking at women who are victims of violence of any kind within family space. So within a family, if there is a woman, she is a victim of domestic violence or violence of any kind in the family, and she has certain rights in the Constitution. So we want to give more effective protection of those rights for such a woman. Next up, let's talk about what is the meaning of domestic violence under the Act. So please remember, domestic violence, it does not necessarily, mean the physical violence or infliction of any injury upon the person, upon the body of the woman. Rather, the ambit here is very huge and very applaud worthy as well. Section 3 of this act has, covered every aspect of harm, be it physical harm, be it mental harm, be it sexual harm, be it, verbal or emotional abuse, be it economic abuse, be it abuse for the purpose of securing dowry or any other property or valuable security unlawfully. So everything is covered under the facet of Section 3. Section 3, let's talk about its provisions, bare act provisions. So it provides that any act any omission, commission, or conduct of the respondent. Who is the respondent? That we'll understand later. But for now, just understand it this way. Whoever is causing domestic violence is the respondent. So any act, omission, commission, or conduct of the respondent that harms or injures or endangers the health, safety, limb, life, or well-being, whether mental or physical, of the aggrieved person, or tends to do so, and includes causing physical abuse, sexual abuse, verbal and emotional abuse, and economic abuse, constitutes the act of domestic violence. Further, it states that harassing, harming, injuring, or endangering the aggrieved person to coerce her or any other person who's related to her to meet any unlawful demand for any dowry or other property or valuable security, it also amounts to the act of domestic violence. Now we need to understand two important definitions. One is the definition of aggrieved person, another is that of respondent. So who is an aggrieved person? Aggrieved person, please remember, is a woman upon whom the act of domestic violence has been inflicted. Now, oftentimes there is a misconception that aggrieved woman can just be a wife, who is alleging that her husband is abusing her. But please remember, the ambit of aggrieved person is also very, very wide. A sister can file, let's say, a domestic violence complaint against her parents or her brother, while a mother-in-law or daughter-in-law can also file DV Act complaint. So the ambit again is very huge. The law defines an aggrieved person as any woman who currently is residing or has been residing in a domestic relationship with the respondent and who alleges that they have been subjected to any act of domestic violence by the respondent. So in order for you to picture or fall into the category of aggrieved person, what are some of the pointers that you may need to note down? Also, all of these pointers that we're making note of, please register these or take a mental note because they're important for your judiciary exams. Let's say RJS is on the way, so it is important there also. Aggrieved person would mean any woman. Now, the woman has been or is in a domestic relationship. Domestic relationship with whom? With the respondent. And what has the respondent done to her? She's alleging that he has inflicted the act of domestic violence upon her. Now, what is the domestic relationship? By domestic relationship, I mean that the aggrieved person and the respondent, they're connected together by certain factors. What are the factors? They can be connected by blood, they can be connected by marriage, they can be connected by relationship in the nature of marriage. That means they can be live-in partners, or they can be connected by adoption or any other way. And they should be living in a shared household. So this means aggrieved person is a woman who is living in a shared household with the respondent. They're connected together by blood, marriage, adoption, all of these ways. And the respondent has committed an act of domestic violence against the respondent, against the aggrieved person. Now, who is the respondent? Earlier, the definition was very narrow. The respondent included adult male. But now the definition has been enlarged, and the respondent can be a woman also. It need not be a woman of any age. It need not be person of specific gender. Even a mother-in-law who's inflicting the act of domestic violence upon the daughter-in-law can also be made a respondent here in the DV Act. Now let's talk about the reliefs and the compensation which is available under this Act. So for that, the most important section for our purpose of discussion is Section 22. It provides for compensation order. Section 24 provides that in addition to other reliefs. Now, please understand, under the DB Act, the foremost, target of it is to grant relief to the women by way of several orders. So you can seek a protection order, you can seek a shelter order, you can seek other orders also. Custody order and compensation is one of those reliefs which are provided under the DV Act. So what is a compensation order? Section 22 talks about it. A magistrate may pass an order directing the respondent to pay compensation and damages for the injuries, including mental torture and emotional abuse, which is caused by the acts of domestic violence committed by that respondent. So if, let's say, a respondent, a husband, has committed domestic violence act upon the woman, the wife, and as a result, some mental or emotional distress is caused, any physical injuries are caused. Now, in order for the harm that you've caused, created, you have to pay compensation and damages. That is covered under Section 22. Now we need to understand Section 12, the mandate of it. So Section 12, it allows an aggrieved person or anyone on behalf of the aggrieved person. By anyone, we mean any service provider, any NGO which is registered for this purpose, or any other entity under the DV Act which is allowed here. They can file an application at the instance of the aggrieved person to a magistrate, asking the magistrate that kindly give us one or more of the relief which are available under the DV Act, including a relief for the issuance of an order for payment of compensation or damages without prejudice to the right to institute a suit for compensation or damages for the injuries caused by the acts of domestic violence committed by the respondent. So Section 12 also talks about a relief for issuance of an order of payment of compensation or damages. Now let's talk about what are the arguments of the petitioner. See, there are two arguments which are at the core of the petitioner's case. One is that the quantum of compensation which is awardable under Section 22 should not depend upon the financial status or income capabilities or paying capacity of the husband or the respondent. Rather, it should depend upon the harm that has been caused to the person or the mental distress that has been caused to the woman or the victim of domestic violence. Secondly, the petitioner's counsel argued that there is a distinction between Section 20 and Section 22. What is Section 20? We'll have a look at it later. Now, if you've read the concept of maintenance, you must have come across some case laws which says that paying maintenance to the wife does not merely mean that you're just paying a very, small sum. It means that the wife should be able to live a dignified life according to the standards that she had been living while there was, the parties were living together as a couple very cordially. So the standard of life should be maintained. This is the general trend in maintenance cases. Now, here the petitioner has argued that the application of this sort of a trend that you have to maintain the standard of living that you were living while paying the maintenance, it is pertaining to maintenance specifically, and that should not be read into a compensation order under Section 22. So let's read their arguments. The senior advocate who is representing the husband raised the question regarding quantum. The counsel submitted that the compensation quantum should be relatable to the damages, to the injuries, including mental torture or emotional distress, which is caused to the victim by the act of the spouse, and it cannot relate to the standard of living of the parties. The counsel further argued that while the standard of living criteria, that you should maintain the standard of living that was hitherto maintained, it can perhaps be made applicable to the cases of maintenance under Section 20 of the DV Act. This, however, cannot be read into a compensation which is awarded under Section 22. Let's talk about Section 20. So it provides for monetary reliefs. It allows the magistrate, while disposing of an application for relief under Section 12, to direct the respondent to pay monetary relief to meet the expenses incurred and the losses suffered by the aggrieved person and any child of the aggrieved person. Where the monetary relief, it should be adequate, it should be fair, it should be reasonable, it should be consistent with the standard of living to which the aggrieved person is accustomed. The magistrate can either order an appropriate lump sum payment or monthly payment of maintenance as the nature and circumstances of the case may require and call for. Now let's talk about some of the case laws in the past that we saw which talked about how to decide compensation. So first we have a 2008 Delhi High Court verdict in the case of Chaturbhuj versus Sitabai, wherein it was held that the object of maintenance proceedings is not to punish a person for his past neglect, but to prevent the destitution of a deserted wife by providing her food, clothing, shelter through a speedy remedy. Further, the Supreme Court in 2017 in the case of Kalyan Dev Chaudhary versus Rita Dev Chaudhary Nee Nandi ruled that the amount of permanent alimony which is awarded to the wife, it must be befitting the status of the parties. It must fit the status of the parties or the standard of living that the parties are accustomed to, they are used to, and the capacity of the spouse to pay the maintenance. The court also relied on its 1970 ruling in the case of Dr. Kulbhushan Kumar versus Raj Kumari, where it held that 25% of the husband's net salary, it would be just and proper to be awarded as maintenance to the respondent wife. Now, these are a couple of pointers which a couple of advocates highlighted using their understanding of the family law. So let's have a look at these to get a clearer picture, maybe the practical insight of it, and then we wait for the Supreme Court's verdict in this matter. So one of the advocates stated that that Section 20, it provides for compensation for all the losses of the aggrieved person, and Section 22 exists to compensate only for the exact injury. The payment under 22, it is punitive in nature, and its objective is not to put the offender to penury, but to set an example and act as deterrent. Further, he added that since maintenance and compensation are governed by two different sections, which is 22 for compensation and 20 for maintenance, there is a gap which exists in legal knowledge on the compensation, on the computation of damages. So due to the absence of clearer precedent here, proposition of law from maintenance cases are often borrowed and applied to DV Act cases or to domestic violence cases. Another advocate added that damages are usually computed on the basis of both the injury which is suffered by the victim and also the financial status of the parties. The court has the discretionary power to decide this value. Often it goes case by case, taking into account the victim and the accused, and the husband's status and the kind of violence that has been inflicted. With this, now let's proceed to the national news category for today. The Indian Renewable Energy and Development Agency, which is a public sector enterprise, a PSE, it has been granted the coveted status or designation of being a Navratna enterprise by the Government of India. Currently, there are total 17 such Navratna PSEs. Another update in the segment of sports for today, Indian athletes, they continue to secure more medals for our country by making impressive medal winning spree at the 21st Under-20 Asian Athletics Championship 2024. Let's talk about some of the athletes. We have Harshit Kumar. He clinched a gold medal in a sport which is highly competitive. It is hammer throw. His outstanding performance goes, and the throw is at 66.7 meters. As far as the total medal tally is concerned, it is 18 medals. It consists of 1 gold, 2 silver, and 2 bronze medals, further cementing India's position as a powerhouse in Asian athletics. Manipal Academy for Higher Education, it honored KV Kamath, who is the chairman of the National Bank for Financing, Infrastructure and Development, and the chairman of Geo Financial Services Limited, with an honorary doctorate at a special convocation. The G7 grouping, it has agreed to end use of unabated coal power plant by 2035. The G7 group, or the group of 7 nations, it announced its members or its members nations, they would end the use of unabated coal by 2035. However, the grouping has given the member countries a leverage to stretch this deadline when particular contexts arise for the need arise for such extension. This happened in while a environment and climate energy talk was going on in Turin in Italy. The group announced that it had committed itself to phase out existing unabated coal power generation in our energy systems during the first half of 2030s. DRDO successfully tests missile-assisted torpedo release system. The Defense Research and Development Organization, popularly known as the DRDO, it tested a next-generation torpedo release system which is aimed at boosting Indian Navy's anti-submarine warfare capabilities. Called Smart System, which is the supersonic missile-assisted release of torpedo. It has been designed by DRDO. India to host the 46th Antarctic Treaty Consultative meeting in Kochi. This is important. Please remember the parties involved here, the addition of the meeting, the venue of it, and maybe the dates of it. So India underscored its commitment to Antarctica's protection and scientific exploration by hosting 46th edition of the Antarctic Treaty Consultative meeting. Let's talk about the parties involved, the venue, and the dates. So the Ministry of Earth Sciences, Government of India, in collaboration with the National Center for Polar and Ocean Research, is set to host the 46th Antarctic Treaty Consultative meeting and the 26th meeting of Committee for Environmental Protection from 20th to 30th of May this year, and the venue is Kochi, Kerala. Google launches AI-powered speaking practice feature for English learning. Google has introduced Speaking Practice, which is an AI-powered feature enabling users to practice speaking English interactively, and this is available in select countries. The AI-driven feature, it is embedded within its search platform, Google, enabling and aiming to enhance users' English speaking abilities through interactive exercises. Next up is an update in the category of important days. We have two such days. One is the World Immunization Week 2024. It has been observed from 24th to 30th of April, and next is the World Tuna Day. The World Immunization Week, it is observed annually from April 24th to 30th. Please remember the dates. And this is to encourage the use of vaccines to safeguard people of all ages across the globe against vaccine preventable diseases and proper uses of vaccines. We just, in the recent past faced a world global pandemic, which was so devastating, and we saw the importance of vaccination then. The theme of this particular day on week is humanly, this week for 2024, it is humanly possible immunization for all. Let's talk about World Tuna Day. It is about tuna fish. So every year, World Tuna Day, it is observed on 2nd of May. Let's talk about its historical background. So in December of 2016, the UN General Assembly voted to observe World Tuna Day every year. The inaugural celebration for this day, it took place in May of 2017. Since then, every year, 2nd of May is celebrated, observed, and dedicated to these species. Let's talk about the significance. This day was announced mainly to raise awareness about the role of tuna fish and how their population is depleting due to unregulated fishing methods and the poor conservation movements and management, poor conservation management. Now let's talk about the international news segment for today. First up is an update from UK. UK's new world first laws crack down on smart cyber attack. The new laws, they are coming into force as part of the Product Security and Telecommunication Infrastructure regime, which has been designed to improve UK's resilience from cyber attacks and ensure malign interference does not impact the wider UK and global economy. Humza Yousaf resigns as Scottish First Minister. Humza Yousaf, Scotland's first Muslim First Minister and leader of the Scottish National Party, is announced his resignation amid political turmoil. Again, we have an update from UK, a law enforcement update with respect to migrants. UK starts detaining migrants set to be deported to Rwanda. British authorities have started to detain migrants in preparation for them to be sent to Rwanda in the next 9 to 11 weeks, laying the groundwork for Prime Minister Rishi Sunak's flagship immigration policy. This is a law to pave the way for sending asylum seekers to Rwanda if they arrive in Britain without permission. It was approved by the Parliament of UK in April. Next up is an update related to personalities. So let's talk about it. Paul Auster, the author, he dies at the age of 77. US author Paul Auster, who wrote New York trilogy, mystery novels, he died at the age of 77. He wrote more than 30 books across his career and he gained cult status in 1980s and 1990s. Pro-China candidate wins Solomon Islands PM vote. Lawmakers in the Solomon Islands, they have selected a pro-China candidate as their prime minister in an indication that the Pacific nation will remain a close ally of Beijing, China. Jeremiah Menel, he won the prime minister vote on Thursday, beating his opponent Matthew Whale in a 31-18 count. Next up is an update in the international sports category. Paris Saint-Germain clinches record 12th League One title. One of the most successful football clubs based out of Paris, France. It has secured its 12th League One title in 2023-2024, solidifying their position as a French football powerhouse under the coach who is Luis Enrique and his leadership. Now, this has brought us to the legal update segment for today. First update coming from the Honorable Supreme Court, and this is an important one. The name of this case, please mark it down. Dolly Rani versus Manish Kumar Chanchal. The Supreme Court has clarified that the legal requirements and sanctity of Hindu marriages under the Hindu Marriage Act. So what is the clarification that the Supreme Court has given? The court has emphasized that for a Hindu marriage to be valid, it must be performed with appropriate rites and ceremonies such as the Satpadi, which is the 7 feras, the 7 steps around the sacred fire, if included, and the proof of these ceremonies is essential in the case of disputes. The court added and observed in this respect, and I would like to quote that out, where a Hindu marriage is not performed in accordance with the applicable ceremonies such as the Saptapadi, when included, the marriage will not be construed as a Hindu marriage. In other words, for a valid marriage under the Hindu Marriage Act, the requisite ceremonies, they have to be performed. And there must be proof of performance of the said ceremonies whenever any controversy, any dispute arises. Unless the parties have undergone such ceremony, there would be no Hindu marriage according to Section 7, and a mere issuance of a certificate by an entity in the absence of the requisite ceremony having been performed, it would neither confirm any marital status to the parties nor establish a marriage under the Hindu law. This is an important update. Next up is another update from the Supreme Court. The Supreme Court commented about the peculiar practice of advocates filing minutes of order in Bombay High Court. Minutes of order essentially are notes which are filed by advocates on both sides, which mention the points which they are to be included, which they are trying to include or they intend to include in the judgment to be passed by the court. So while this practice is to assist the judges, the Supreme Court cautioned that care should be taken to ensure that the rights of third parties are not affected by passing orders based on the minutes of orders. Further, the High Court must apply its own mind to the minutes of order to ensure that the order which is proposed to be passed, it is lawful, so the exercise of judicial mind should be there. The name of this case is Ajay Ishwar Bhutia and others versus Meher K. Patel and others. Another update from the Supreme Court. Supreme Court directed the implementation of a minimum 1/3 women's reservation in the posts of Supreme Court Bar Association henceforth, including the ensuing elections. The court further directed that in the ensuing elections for 2024-2025, the post of treasurer of the Supreme Court Bar Association, it shall be reserved for women candidates. The name of this matter is Supreme Court Bar Association versus B.D. Kaushik. Another update from the Apex Court. This is with respect to Section 205 of the CRPC. So the Supreme Court has observed that even before the grant of bail, the accused can be exempted from showing his personal appearance before the court. The court added that the observation of the High Court that there is no provision for granting exemption from personal appearance prior to obtaining bail, it is not correct, as the power to grant exemption from personal appearance under the CRPC, it should not be read in a restrictive manner as applicable only after the accused has been granted bail. So court can exempt accused from personal appearance even before the grant of bail in exercise of the powers under section 205 of the CRPC. The name of this case law, I'll confirm it tomorrow. This must be a repetition. All right. So with this, we've come to an end to the TNA. Thank you so much for being with us. Have a wonderful weekend ahead.